in the United States versus Freer, Disability Rights Law Book, page 512, Chapter 5, Private Housing and Public Accommodations. We read Teliska's summary of the decision made at the United States District Court for the Western District of New York in 1994. The United States of America brings this action for declaratory and injunctive relief on behalf of the complainant Ann Soper under the Fair Housing Act. She is a disabled individual who resides in a trailer park owned by the defendants Jack and Beverly Freer. The government alleges that the defendants failed to make a reasonable accommodation for Ms. Soper's disability by refusing to allow her to install a wheelchair ramp to gain access to her trailer. The government seeks a preliminary injunction enjoining the defendants from continuing to withhold their approval of Ms. Soper's request to install a wheelchair ramp, although the government also seeks declaratory relief and monetary damages. In this action, those issues are not before the court at this time. For the following reasons, the government's motion for preliminary injunction is granted. Ms. Soper is a disabled individual who is confined to a wheelchair. She has a trailer home which is located in the defendant's trailer park. In order to enter the trailer, Ms. Soper must climb 5 steps without a wheelchair ramp. Ms. Soper needs to be carried or otherwise attended up the steps and into her home. Recently, while being assisted into her home, she fell and was injured. Prior to her accident, Ms. Soper had asked the defendants for permission to install at her own cost a wheelchair ramp which wrapped around the side and front of her trailer and partially protruded into her driveway. The defendants refused to allow installation of a ramp with that configuration, claiming that it would impede trailer removal and would so shorten Ms. Soper's driveway that parked cars would obstruct her trailer park's access road. The defendants proposed an alternative ramp design which Ms. Soper has rejected as unsuitable to her needs. The Fair Housing Act. The Act, according to United States Code Title 42, Section 3604 F2, prohibits discrimination against handicapped individuals in terms, conditions, or privileges of rental of a dwelling or in the provision of services or facilities in connection with such a dwelling. Under the statute, unlawful discrimination includes a refusal to permit, at the expense of the handicapped person, reasonable modifications of existing premises occupied or to be occupied by such persons if such modifications may be necessary to afford such person full enjoyment of the premises, except that, in the case of a rental, the landlord may, where is it reasonable to do so, condition permission for a modification on a renter agreeing to restore the interior of the premises to the condition that existed before the modification and reasonable wear and tear accepted. The government has established a prima facie case of discrimination under the Act. There is no dispute that Ms. Soper qualifies as a handicapped person under the Act. The defendants knew of her handicap and refused to allow her to install a wheelchair ramp at her home. Unquestionably, the defendant's refusal to permit installation of the ramp was effectively denying Ms. Soper an equal opportunity to use and enjoy her home. The defendants have failed to rebut the presumption of discrimination by demonstrating that Ms. Soper's proposed modification is unreasonable, imposes upon them an undue financial or administrative burden. The defendants claim that Ms. Soper's wraparound ramp proposal will make trailer removal and driveway parking difficult, thereby obstructing traffic using the access road. Instead, they propose an alternative design which meets all applicable laws and codes, does not block the driveway, and costs no more than Ms. Soper's proposed ramp. The government has clearly demonstrated a possibility of success on the merits of the claim. There is no dispute that the defendants have refused to accommodate Ms. Soper's disability by not allowing her to build the wraparound wheelchair ramp pursuant to the Act. The defendants are obligated to approve Ms. Soper's ramp proposal unless it is proven that the proposal is unreasonable. The defendants cannot accomplish this by tossing Ms. Soper's proposal aside and pressing for acceptance of their alternative design. So their counter argument must first find the proposal to be unreasonable. So the counter argument that the alternative design being allowed must first find the proposal to be unreasonable. And this court is unconvinced that Ms. Sober's ramp proposal is unreasonable. Installation of the ramp will not impose an undue financial burden on the defendants because Ms. Sober is assuming the construction costs. The defendant will not suffer undue administrative burden should the ramp be built. The government has stated that Ms. Sober's proposed ramp can be disassembled within 3 hours and will not impede removal of the trailer. This court has also reviewed a photograph of the Soper driveway, which sheds substantial doubt on defendant's claim that installation of Ms. Sober's ramp design will impede traffic. On the driveway on the access road. In short, the defendants have submitted insufficient evidence to rebut the inference of discrimination under the Act, wherefore the government's motion for a preliminary injunction is granted. The defendant shall allow Ms. Soper to install her proposed wraparound wheelchair ramp. The issue of damages is deferred to a future date. And that's your conclusion. Since that was so short, we're going to read the notes on accessibility under the Fair Housing Act. The Fair Housing Act's physical accessibility requirements incorporate the same sort of old-new distinction as appears in Title III's accessibility requirements, but there is one significant difference. Unlike Title III, which requires the covered business to pay for barrier removal in older facilities, the Fair Housing Act requires only that older facilities permit, at the expense of the handicapped person, reasonable modifications of existing premises occupied or to be occupied by such person if such modifications may be necessary to afford such person full enjoyment of the premises. Why does the Fair Housing Act require the individual with a disability to pay for the barrier removal while Title III requires the business owner to pay? Is the reason simply one of administrative efficiency, that it is easier to charge a resident with a disability who specifically requests barrier removal than it is to charge the customers with disabilities who may benefit from barrier removal months or years later? Or does the distinction reflect a normative judgment that people with disabilities should bear the cost of accessibility in the places where they live, but not in the businesses they patronize? What arguments must justify this sort of public-private distinction? Note the distinction parallels the job-related rule in the enjoyment context, which holds that employers need not pay for accommodations that assist a worker with a disability outside of the workplace. The requirement to pay for one's own barrier removal might have countervailing benefits for people with disabilities. However, in Freer, the court holds that the trailer park owner must permit Ms. Soper to make a reasonable accommodation of her choice. Even if the trailer park would prefer that she build her ramp in another way, and even if the trailer park's preferred ramp design would be reasonable, the park must nonetheless permit Ms. Soper to build according to whatever reasonable design she prefers. In the employment context, as Chapter 3 demonstrates, the rule is the opposite. Even if the preferred accommodation of the employee with a disability is reasonable, she must nonetheless accept whatever reasonable accommodation the employer chooses. You might think of this rule as the who pays the piper rule, and presumably because the person to permit more extensive barrier removal efforts than are required under the ADA, reasonable modifications of existing premises as opposed to readily achievable barrier removal. Okay, so the reason why this is the way that it is, which they never answer here, is because the individual knew the state of the building before they applied to rent it, and they chose to apply for it because they wanted it and chose to make the accommodations. Whereas if they're going to the post office to drop a letter, they don't really have a decision about how to access that building. They get what they get, and that's why the public bears the burden, whereas in the private, distinction is made.